What many of you may not know is that children are the fastest growing audience on the internet today. 40% of all new internet users are children, which I'm defining as anyone under the age of 13, based on the traditional magic number that the US has provided us, which is of course going up as we speak. But about 170,000 kids go online for the first time every day. That's according to UNICEF. And of course, as we know, the internet was not really built for them. In fact, quite the contrary. All of the internet infrastructure that exists today was really built for adults, and it was built and designed to collect as much data as possible, including personal data. And as a result, children are being fingerprinted and profiled on an industrial scale today across the internet, across social media, across many websites and apps, some of which are designed for kids and trying to be compliant, many of which are not designed for kids and don't even know where to begin to be compliant. And this is really the reason why we started SuperAwesome 6 years ago, to try and alleviate this issue and start to build some alternative infrastructure that doesn't collect personal data. As a result of this, we do now, of course, have a growing number of data privacy laws that specifically protect children. It all started in the US with COPPA, of course, which we're going to talk about very briefly in a moment. But then we have GDPR and what we like to call GDPR-K, which is the provisions in GDPR that are designed to protect children. But beyond that, we also have more protections for children in other countries. China's new cybersecurity law and the Personal Information Security Standard has explicit provisions to require parental consent before you collect personal data from children, very much modeled on Article 8 of the GDPR and COPPA. For China's purposes, a child is anyone under the age of 14, so somewhere in between Europe and the US. But in other countries, similar provisions are emerging. India's new data privacy bill that is being debated in Parliament has explicit provisions protecting children, in this case, anyone under the age of 18. Brazil's new data privacy law also has explicit provisions protecting children. So what you can see here is that starting with COPPA and moving through GDPR, we now have a global trend where it is commonly understood under the law that we shouldn't track children, that we shouldn't profile children, and that we shouldn't collect personal data from children unless we have a measure of parental consent, which should be verifiable at some level. Now, that's all nice and well to have these laws in place, but in actual fact, it is virtually impossible to comply with these laws if you are operating on the internet, either as a large website owner or as an advertiser or as an independent developer or in almost any capacity. It is really, really hard. And so it's going to take some time for the industry to catch up and to be able to apply these laws and to comply with them using existing technology. If we just take a different perspective on the spread of data privacy laws, so this is a recent report that we commissioned from PwC about kids' digital marketing in the world. And what they found is that, based on COPPA and the kids' provisions in GDPR, today we have about 130 million children, defined as under 18 in this case, under 16, sorry, protected by data privacy laws specifically. If you add in India, if you add in China, and you look at what's happening in other parts of the world, very soon we will have close to 1 billion children notionally protected by data privacy laws. So there's a huge growth market here for anyone who can help enable this or make this easier from a technology perspective or process perspective. Very briefly, where it all started, of course, is COPPA. I'm sure many of you are familiar with it. It's the Children's Online Privacy Protection Act. Didn't really become relevant to anyone in digital marketing, for example, or online until 2013, when, of course, the definition of personal information was expanded to include persistent identifiers, voice, video, audio, and geolocation. And this was a really radical move at the time by the FTC. Because, of course, in most cases, we thought about personal information as being the kind of traditional stuff you see here on the right. And COPPA says, kids should not supply this kind of information to strangers unless they have parental consent, which makes obvious sense. But because of the rapid growth in the interim up until 2013 of behavioral advertising, location-based services, and social media, the FTC decided that they needed to do something and expand this definition. And at the time, this was pretty controversial because in 2013, nobody in the digital advertising industry could even figure out how to deliver an ad without collecting persistent identifiers, without collecting an ad ID, or a device ID, or an IP address, or a user agent, or something like that, or a cookie ID for that matter. And so for a brief moment there, the whole industry was really pushed out of the kids market. And legitimate advertisers, the Legos, the Disneys, the Mattels, who want to engage with kids online, who are trying to move their marketing budgets from TV, linear TV, which kids aren't really watching anymore, to digital, were really struggling. And of course, the FTC was very clear that they didn't want to stop digital advertising to kids. In fact, when they laid out the exceptions to the rule, in other words, they said you can still collect persistent identifiers provided you only collect them for purposes of one of these 6 exceptions, which included contextual advertising and internal operations, so the things you need to support your analytics, your infrastructure, your security, and so forth. Even though the FTC had provided these exemptions, it was still really hard to adapt the adult infrastructure to be able to work in this way and to ensure that the IP addresses and the cookie IDs you were collecting for these purposes weren't misused elsewhere or didn't leak out to another party who would misuse them elsewhere. But after a while, the market settled, and today, for most of the big digital advertisers that have legitimate reasons to engage with kids, they fully accept that this is the way they operate in the US. And in fact, many of them, including some of your favorite kids' brands, have been making this a global policy since long before GDPR, since 2016, 2017, for example, where they don't track kids, they don't do user profiling, they don't do behavioral advertising, or any of the things that would fall afoul of COPPA. So COPPA was really, in many respects, the test lab for how we can protect children's data privacy. The law is not perfect, big gaps there, and we're seeing some of those gaps being addressed now through FTC action and litigation around social media, for example, and around programmatic advertising. But a pretty good start in helping companies that want to be compliant, that don't want to collect data on kids, do so with cover of the law.